In October 2021, the Home Office introduced a concession called Concession to the Family Immigration Rules for granting longer periods of indefinite leave to remain and early indefinite leave to remain. The concession is aimed at young adults aged between 18 years and 24 years. Ordinarily, the young adults would have been granted sometimes five-year leave to remain, or mostly if the parents didn't have any leave to remain, or if the young people didn't have any leave to remain, would have been granted under the 10-year route. The Home Office has recognized that in the best interest of these young people, we have spent mostly half of their life in the United Kingdom, or have spent most of their time in the United Kingdom. It is in their best interest that they be granted an early indefinite leave to remain. So instead of them waiting for 10 years to be granted indefinite leave to remain, where they qualify, these young people may be granted indefinite leave to remain after 5 years. In line with the 5-year rule that applies to most people who were under the 5-year route. Most young people were struggling because they had to wait 10 years before they could get indefinite leave to remain. But that impacted or affected them. For example, if they wanted to go to work, or if they wanted to study, they had to study as international students. They didn't qualify for the local rates and so forth. So this concession is mainly for their benefit. So under the policy, an individual will only be eligible for early indefinite leave to remain where they meet the following criteria at the point of applying. They must be aged between 18 or above and under 25 years, and must have spent at least half of their life living continuously in the United Kingdom, discounting periods of imprisonment. They must have been either born or entered in the United Kingdom as a child. They must have held limited leave to remain in the United Kingdom for 5 years. They must be eligible for further leave to remain under paragraph 276 ADE1 and must have made an application under those rules. Once the initial eligibility screening has been satisfied, the decision maker will then need to consider what they consider is proportionate or appropriate as it is described in the policy. When undertaking this assessment, the policy directs the decision maker to take into account a specific but inexhaustive list of factors to include the following: the person's age when they arrived in the United Kingdom, the length of their residence in the United Kingdom, including a lawful residence, the strength of their connections and integration in the United Kingdom, whether unlawful residence in the past was the result of non-compliance on the part of the applicant or their parent, whilst the applicant was under the age of 18. Efforts made to engage with the Home Office to regularize their status. Any leave currently held and length of the continuous leave being held. Any period of any continuous leave held in the past. Whether and to which extent limited leave to remain will be detrimental, will have, a detrimental impact on the person's health or welfare. So these are some of the considerations that the Home Office will take into account. This is a forward-thinking, positive concession that has been made by the Home Office in order to assist young people who have been in the United Kingdom for at least half their life, aged between 18 and 24 years. In one of the presentations that I did recently, I also touched on the fee waiver that has been done by the Home Office for children when applying for citizenship. If you require any legal assistance in terms of immigration, whether you're a child or an adult, you can contact us, TAN Law Solicitors, and we are based in Coventry, and we've got clients all over the UK and indeed all over the world who have got immigration matters. My name is Andrew, and I'm a solicitor at TAN Law Solicitors.